Sir, court officer, sir. ವಿಡಿಯೋ ಆಫ್ ಆಗಿದೆ ಸರ್. ಇದೂ ಮ್ಯೂಟ್ ಅಲ್ಲಿದೆ ಮೈಕ್ ಸರ್. ಇವಾಗ ವಿಡಿಯೋ ಬಂದೈತೆ. ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಆದ್ರೆ 28 ಏನೋ ಬರೆಯೋದಕ್ಕೆ ಜಾಸ್ತಿ ಇದೆ ಅಂತ ಇದು ಗಂಗದ ಅದಕ್ಕೆ ಹೋಟೆಲ್ಗೆ ಅವ್ರು ಹೆಂಗೆ ಬರೀತಾರೆ ಬಂದಿದೆ. ಇದು ಕಾಲಾಗಿ ಸ್ಯಾಟರ್ಡೇ ಸಂಡೇ ನಿಂತಿರೋದು ಯಾರು ವಾಶ್ರೂಮ್ಗೆ ಹೋಗ್ತೀರ ನಾವೇ ವಾಶ್ರೂಮ್ ನೀವು ಲಿಬರ್ಟಿ ಇದೆ. ಆಮೇಲೆ ರಜಾ ಅಂತ ಧೈರ್ಯ ಫೋನ್ ಮಾಡಿ ಹೇಳಿದ್ರೆ ಇಷ್ಟ ಮುಗಿದೋಗ್ತಿಲ್ಲ. ಶನಿವಾರ ಒಂದು ಕೇಳ್ತಾಗುತ್ತೆ ರೆಸಾರ್ಟ್ ಕೊಡ್ತಾರೆ. ನೀವು ಹಾಕಿ ಪ್ಯಾನ್ ಹಾಕ್ತಿದ್ದೀವಿ ನಿಮ್ಗೆ ಬೇಕಾ? ಇಲ್ಲ ಬೇಕಂತ ಹೇಳಿ, ಬೇಕಂದ್ರೆ ನೀವು ಒಂದು ಹಾಕಿ ಟಿಕೆಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿರೋದು. 23 ನೋಡಿ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಅಂತ ಹಾಕಿದ್ದಾರೆ. ನಿನ್ನೆ ಗಿಣಿಗೆ ಹೇಳ್ದಂಗೆ ಹೇಳಿದೆ ಸ್ಟೇ ಇದೆ. ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ CID ಇದ್ದಾರೆ. ನಿಮ್ಗೆ ಬರುತ್ತಲ್ವಾ ಅದು?
CID ನಮ್ಗೇನೆ ಬರ್ತದೆ.
ಸರಿ, ಲಾಸ್ಟ್ ಅಕೇಶನ್ ಆಗಿದೆ. SCGP ಟೇಕ್ ನೋಟಿಸ್ ಫಾರ್ ಬೋತ್ ಅಂತ ಇವತ್ತು ಹೇಳ್ಬಿಡ್ತೀನಿ. ಇಲ್ಲಿ ಇವಾಗ ಅದಕ್ಕೆ ರವಿ ನನಗೆ ಹೇಳಿದ್ರು ನಿಮ್ ಕಾರ್ ಆಗಲ್ಲ ತೊಂದ್ರೆ ಇಲ್ಲ ಡ್ರೈವರ್ ಯಾರಾದ್ರೂ ಬಂದ್ರೆ ನನಗೆ ಈಗ ಅವಾಗ ಇವ್ರ ಡ್ರೈವರೇ ಮೇಡಮ್ ಡ್ರೈವರೇ ಆಗ್ತಾರೆ 7 ಜನ ಆಗ್ತೀರಾ ನೀವು ಡ್ರೈವರ್ ಎಂತ ಆಗ್ತೀವಿ ರವಿ ಮತ್ತೆ ನೋಡೋಣ ಹೆಂಗ್ ಬರುತ್ತೆ ನಿಮ್ಮ ಹತ್ರ ಇರೋದು ಯಾವ್ದು ಕಾರು ಇದು PS ಇವರು ರವಿ ಹೋಗಪ್ಪ ಅಂದ್ಬಿಟ್ರು ಮೇಡಮ್ ಮೀಟಿಂಗ್ ಕರೆದಿದ್ದಾರೆ ವರಲಕ್ಷ್ಮಿ ಮೇಡಮ್ ಏನೋ ಕರೆದಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ 486 ಬರ್ಕೊಂಡಿದ್ದಲ್ಲ ಅಷ್ಟೇ ಬರ್ಕೊಳ್ಳೋಣ ರೆಕಾರ್ಡಿಂಗ್ ಅನ್ನೋದು ರೆಕಾರ್ಡಿಂಗ್ ಅನ್ನೋಬಿಡ ಎನಿ ಮೆಮೋಸ್
Yes. Yes, I file ಮಾಡಿ.
Any adjournment? List 1.
1 April.
List 1, page 5, serial number 18 to 23.
Serial number? Serial number? 8. 8 ಏನಿದೆ?
Hearing
ಅಯ್ಯೇ. ಯಾರು for the petitioner? ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು? ಗವರ್ಮೆಂಟ್. ನೀವು ಹಾಕಿದ್ದ? You have filed the application. On merits it will be heard. Address the arguments on merits. Counsel for the petitioner. Raise for time to raise learned counsel for the petitioner. ಯಾರಿದ್ದಾರೆ?
My lord, serial.
Okay. Learned counsel for the petitioner undertakes to address his argument on merits instead of hearing IA 1 of 2023. He also undertakes to address his argument on the next date of hearing on merits. Learned HCGP has no objection for the same. Hence, IA 1 of 2023 is ordered to be heard along with the criminal petition. List for admission. Final hearing idre admit agidre final hearing. First. Yes. Get ready on the next date of hearing. No further adjournment. Next.
Page 6, serial number 24 to 28. List 1, page 1, serial number 1, K. Lakshmikant.
You have to pay PF, sir. Huh? It is not served. So you have to pay PF once again. But PF ಕೊಡ್ಬೇಕಲ್ಲ. Pay PF, pass over. Pay PF.
Serial number 2, Sheikh Ismail Zabiullah.
ಹೌದಾ? Take notice. Learned HCGP takes notice for respondent number 2 as well. You address the arguments on merits. Learned counsel for the petitioner undertakes to address arguments on merits on the next date of hearing. Hence, learned HCGP has no objection to hear IA 1 of 2023 along with the main matter. List for admission. Interim order is, but provided you address the argument on next date. Yes.
Serial number 3, Raghuram Kadambi.
I beg to appear on behalf of the petitioner, my lords. I filed a memo seeking withdrawal of the present petition, my lords.
Learned counsel for the petitioner filed a memo seeking withdrawal of the criminal petition. Memo is placed on record. Petition is dismissed as withdrawn.
My
Yes.
lords, may I request, may I make one submission, my lords? Can liberty be granted, my lords?
Why no liberty, sir?
Please, grateful.
No. Next. Next.
Petition number 4, Dhananjay Vidyapati Joshi.
Withdrawal of the petition. Counsel for the petitioner filed a memo seeking permission to withdraw the petition. Memo is placed on record. All memos, different memos or single memos are placed on record. Petition dismissed as the same is withdrawn.
Serial number 5,
IAs ಏನಾರು ಇದ್ರೆ ಅದನ್ನ dispose ಮಾಡಿ.
hearing on IA, Hadish Ganapati.
Argue on merits. ನೋಡೋಣ. ಮೆರಿಟ್ಸ್ ಇದ್ರೆ ಇದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡೋದು. ಒಂದ್ ನಿಮಿಷ. Second time. No justifications. First time, 21-1. ಇವತ್ತೆಲ್ಲ. On merits, ready? Otherwise, I'll dismiss everything. Who is the petitioner? Accused number? 1 and 2. In all, how many accused are there? Only 2. What are the offense alleged? 4. ಏನು ಗೊತ್ತಿರೋದಿಲ್ಲ. Then one ನಿಮಿಷ. FIR in 195 of 2018. Of which police station? Initially, private complaint was filed. PCR number 387. Quick ಇರ್ಬೇಕ್ರಿ. ಏನ್ ಸುಮ್ನೆ ಎಲ್ಲದನ್ನು ಹುಡುಕೋದೇನಿದೆ? Facts ಹೇಳ್ತಾ ಹೋಗಿ. Investigation was undertaken. Filed charge sheet. ಎಲ್ಲಿದೆ charge sheet? ಆಯ್ತು. Go before the trial court. ತಗೊಳ್ಳಿ. No, nothing. Heard learned counsel for the petitioner. It is noticed that the petition was initially filed during 2019. Since the petitioner, learned counsel for the petitioner was not diligent, the petition was came to be dismissed by default, that is for non-prosecution. And now the application for recalling the order dismissing the petition by default is filed. On hearing the learned counsel for the petitioner, it is for learned counsel for the petitioner and learned HCGP. It is found that the investigation is completed and charge sheet is filed by the investigating officer. The charge sheet is not produced before this court. by the learned counsel for the petitioner for the reasons best known to him. Very serious allegations are made against the petitioners who are read as accused number 1 and 2. Even on merits, they are not entitled for grant of any relief. Hence, I do not find any reason to entertain the application. IA 2 norms are not fully. So and so. Accordingly, IA is dismissed. Yes. Dismissed.
Prasad? Purnima, take.
Hmm?
So we have filed this application.
What is this application?
This is an application seeking substitution of Yes Bank with the JC Flowers as a
Substitution of?
Substitution application because JC Flowers has now moved into the shoes of Yes Bank by an assignment agreement. So the loan has been assigned to JC Flowers. That's the substitution of my name, JC Flowers. IA number 1 because it is. Page number 11 because it's the assignment agreement.
Yes, no objection.
Lord, I would,
Yeah, okay. Sir, application when it was filed?
Well, this was filed in 23 minutes, 6th of March 23 minutes.
No one may consider.
my lord, I may have submissions, my lord, because I'm for respondent number 2. My lord, I'm for the original borrower. Now here, my lord, so far as Yes Bank is concerned, I have already had entered into an OTS with them. Now, my lord, that amount is not shown by JC Flower. JC Flower now wants to come on record by not showing that amount at all. So insofar as Yes Bank is concerned, I've paid some amount. As far as JC Flower is concerned, I've paid some amount. Now, insofar as their substitution is concerned, my lord, my debt was with Yes Bank. Now, the assignment, yes, I do understand there was an assignment. But, my lord, that appropriation should also happen. I will file my objections. I've not been served a copy though because my lord, I'm R2. I'm already on record. We also,
Objections you can have.
my lord, now insofar as JC Flower is concerned, because that debt now, my lord, it comes to me because insofar as petitioner is concerned, he is an independent director. I have other directors also, my lord, because they want to proceed against the other directors. Now here as a company, that amount is not appropriate at all. Where is that amount then?
They bound to appropriate.
They have to, my lord. That's exactly where.
You can take that.
My lord, let them serve a copy of that application to me. My lord, I'll place everything on record. I have not been served a copy.
You're for respondent number?
R2, my lord. R2, the original borrower.
Respondent number 1 undertakes to serve the copy of IA 1 of 2023 on the learned counsel for respondent number 2. Who in turn prays for time?
ಇಲ್ಲ ನಾನು ಆಗ್ತೀನಿ 2 weeks ಬೇಕಾಗುತ್ತೆ because I need to produce all of this.
Also prays for time. The application is filed in the year 2020. Learned counsel for the petitioner and respondent number 2 undertake to file objections and also to address the argument on the application on the next date of hearing. You, both of you, all of you, please.
May I just request only after 7th, my lord, because I have to get instructions from Bombay. It has to come from Bombay.
But come prepared on merits also.
My lord, I will, my lord, nonetheless. But just a date of.
Currently, I will not hear IA 1 of 2023.
Please, but my lord, without just one technicality, without JC Flower coming on record, today, my lord, there is no
Let me
case.
see, sir. If
Please.
I feel that, I will.
I will.
Not allowed to. I might not be able to file my objection. So, let us kindly hear this application separately. Then I'll be able to file my objection.
See, if I were to consider this IA 1 of 2023, I have to hear the matter on merits.
Please.
For
Right.
this application, there is no requirement to hear the
You
full
keep ready your objection.
I'll keep
I
ready
will.
now.
It would come to a situation.
Grant any time for that. You keep it ready.
I'll keep it ready.
Keep it ready.
But
If
you know,
your
I might
application,
be able to file that.
if your application is dismissed, everything goes. If it is allowed, immediately you can file it. For that, I will not adjourn.
No problem.
Yes.
I'll keep my objections ready
Yes.
on that day, but I might not be able to physically file that. Since my
Sec-
application-
I will receive it here. But all the three of you should be ready.
I'll put that objections copy on this. If I can serve them advance also.
Yes, you can
I
do
can
it.
serve them advance.
You can do that.
My lord, after 7th of February.
Yes. ಅಲ್ಲ ಅದು ಎಂಡ್ ಅಲ್ಲಿ ಬೇಡ. Then it counsel for the petitioner respondent numbers 1 and 2 undertake to address their arguments merits along with IA 1 of 2023 on the next date of hearing without fail. Submission is placed on record. This time. Yes. Be ready to address the argument.
No date, my lord, after 4 weeks, my lord? Because
ಆಮೇಲೆ ತಗೊಳ್ಳಿ sir. Don't insist
ಅಲ್ಲ
upon-
ನನಗೆ only I'm just requesting my lord, one more small issue, because in fact my learned friend and I, we were just battling it out on Saturday. Here now the stay, my lord, stay in one matter is with regard to only the petitioner. One matter, the entire proceedings are there. My lord, trial court may be directed not to proceed with the matter, my lord, till then.
ಈಗ ಏನು ನಾನು ಮಾಡಲ್ಲ. You get ready to address the argument.
Please.
21 matter. I do
Please,
not
I
know
do
what is the
understand.
stage.
No, my lord, there was a lot, my lord, which transpired in between, because we settled the matter and thereafter a lot happened.
Yes. Yes. Next.
Serial number 7.
Please,
Venkat
please.
Somareddy.
May it please, my lords, with permission, my lords, I am appearing on VC with permission, my lords, for the learned counsel, my lords. My lords, IA has been filed, my lords. Your lords may kindly take up on the merits, my lords.
Argue on merits.
Please, my lords.
Yes.
Your lords may kindly fix a date, my lords. As your lordship pleases.
Wherever such an application is filed, please get ready on merits.
Please. I am actually ready, my lords. Your lords may kindly fix up a date, my lords.
If you are ready today, I can take up.
I'm ready. I wish to do it physically. Any day, your lords may fix up, my lords.
Huh?
I may kindly be permitted to come physically and make my submissions, my lords. Any day, your lords may kindly.
Senior advocate for the petitioner undertakes to address this argument on the merits on the next date of hearing. Learned HCGP has no objection. Hence, IA 1 of 2024 is ordered to be heard along with merits. List for admission.
Please, my lord, R2, Learned HCGP may be directed to take notice, my lord. R2 is also the department of the government, my lords. It's
Ready
Please,
to be- Other first ಬರ್ಕೊಳ್ಳಿ. Learned HCGP takes notice for respondent number 2.
interim order may kindly be extended.
Yes. ಇವತ್ತಿದ್ರೆ extend ಮಾಡಿ.
Grateful.
Next.
Serial number 8 Arjun. 9 Govind Raju K. PM Sidmalappa.
Pass over.
Serial number 10 K. N. Subbareddy. J. Naveen.
No, vacating stay is filed.
Yes.
I will not extend the interim order. You can address the arguments on merits on the next date of hearing. So, counsel for the petitioner prays for time. The HCGP opposes the move for adjournment. As the petitioner is enjoying the benefit of the interim order, IA 1 of 2023 is filed long back seeking vacating of the stay. In spite of that, the learned counsel to the petitioner is not addressing the argument. I do not find any reason either to extend the interim order or to adjourn the matter, however, to afford a final opportunity to address the arguments on merits. List down. Yes. List for admission. List for admission. You should get ready to address the arguments on merits. Next. Huh? Next one. Next. Finally, as a last. Next.
Serial number 11 R. Pallava.
My lord, I appear for the petitioner, my lord.
Yes,
The only offense which is alleged is section 306 of IPC.
306.
306 of IPC, my lord, and the respondent number 2 complainant is a police officer. My lord, he receives a message from the deceased Nagesh. He receives a WhatsApp message. Police officer, respondent number 2, my lord. He receives a message from deceased Nagesh the night before, stating that the petitioner is responsible for the death of himself and his entire family, consisting of his wife and 2 minor children. Because, my lord, allegedly the petitioner accused tried to convert his wife Nagalakshmi to Islam religion, Muslim religion. This is the allegation.
There is a WhatsApp message, is it?
The complaint states so, my lord, because in the complaint, the police officer, respondent number 2, states that he received a text message on his official mobile number from the deceased Nagesh.
All the family members have died?
Yes, my lord. Now, my lord,
How
insofar as
many?
my lord, Nagesh is the husband,
Huh.
Nagalakshmi is the wife, and 2 minor children. They belong to Bagalkot district. They had come to Mangalore searching for work. This deceased Nagesh, my lord, was working as a watchman in the apartment complex, and this his wife Nagalakshmi was working as a housemaid. He used to go to various apartments.
All have committed suicide by
No, my lord.
having.
Here, what has happened is this Nagesh is a drunkard. My lord, he was habituated to alcohol. He used to
No,
come
that
home
is to
drunk.
be found out, sir, whether investigation is undertaken.
Investigation has to be carried out.
Let the investigation be undertaken.
My lord, the allegation is that your lordship may
Yes.
kindly turn to the complaint, my lord.
Now the complainant has made certain allegations. The veracity of that is to be tested.
My lord, even if the allegation is taken to be true on its face value, my lord.
Mm.
My lord, the allegation is that I tried to convert his wife to my religion.
Mm.
Even if that be so, my lord, even if I had tried so, would that amount to abatement of suicide, my lord?
Whether that
But-
would amount to abatement is to be considered, sir.
My lord,
Can
my
a
lord,
opinion be formed at this stage without there being any merits,
My lord,
any materials?
my lord, I'll appear through physical because I would like to place some citations.
Pass over.
My lord, then your lordship may kindly fix it. I have some inconvenience today, my lord. Maybe
Pass
day
over,
after
sir.
tomorrow or something. Day after tomorrow.
Come at 2:30. Please come at 2:30.
Serial number 12, B.A. Jagdish, N.R. Jagdishwara.
I am for the second respondent, my lord. In this matter, my lord, the matter has settled before the civil judge court, my lord, wherein, my lord, the respondent number 2 undertake to withdraw all complaints made against him. So the appeal, the criminal petition may be allowed, my lord. We have no objection at all because it's arrived in respect of the agreement of sale, in respect of OS 52, which was pending.
You are representing whom?
Respondent number 2, I made a complaint against the petitioner, my lords.
Hmm.
I filed a PCR, my lord, PCR number 9 of 22. Based on my complaint, my lord, crime number 72/22 was
registered.
yes.
No, where is such a compromise entered into?
In OS number 52/22, my lord, 21, my lord.
Produced it here.
In fact, my lord, I filed a memo along with the order copy, my lord. I didn't know the date exactly when it was filed, my lords. '20, 12, 23, my lord.
Yes, in view of this, I will allow the petition.
Please, my lord. Please, my lords.
Third minute counsel for the petitioner. Learned HCGP and learned counsel for respondent number 2. Learned counsel for respondent number 2 submit that he has already filed a memo dated 5/4/2024 seeking allowing of the petition and quashing of the criminal proceedings. Since there is compromise between the parties amicably and the memorandum of compromise was filed in OS 52 of 2021 between the same parties that was pending before the Lemon Principal Senior Civil Judge at Nagadi. Peruse the memo filed by the respondent number 2 and his and her counsel, saying no objection to allow the petition by quashing the LIR against the petitioner and the criminal proceedings. The memorandum of compromise petition under section 23, under order 23, rule 3, read with section 151 of CPC, filed in OS 52 of 2021 on the file of the learned principal senior civil judge at Nagadi. He is produced here, which reads as under. When counsel for the petitioner and respondent number 2 submit in unison that both the parties have entered into such compromise, and in view of the same, the petition is to be allowed. The memo dated 5/4/2024, the memorandum of compromise petition filed in OS 52 of 2024, and the submissions are placed on the file. satisfied with the terms of compromise between the parties. In view of above, petition is allowed. Criminal proceedings in so and so first. Petition is allowed.
Oblige, my lords.
You have to file a memo, ma'am. You are having our ಹೆಸರು ತಗೊಳ್ಳಿ. So and so represents the petitioner. Office is directed to show. Yes, next.
Serial number 30, R.V. Shivanand Reddy takes out.
ಅದಕ್ಕೆಲ್ಲ objection ಬೇಡ, you argue on merits ಅಷ್ಟೇ. Counsel for the petitioner undertakes to address his arguments on merits instead of arguing on IA 1 of 2023. Then counsel for the CGP has no objection if the learned counsel addresses his arguments on merits. It is noticed that the petitioner is enjoying the benefit of the interim order and the petition is of the year 2022. Hence, the counsel for the petitioner is directed to address his arguments on merits on the next date of hearing. List for admission. Get ready to address arguments on merits. Next, no further adjournment will begin. Next.
Serial number 14, Chandrakumar R. S. Nagraj.
I will say.
Who petitioner? Now, how many petitioners are there? 5 petitions. Petition number 1 died. Then counsel for the petitioner submits that petition number 1 died. When he died? 24. Hence, the petition filed by petition number 1 is dismissed as awaited. Connected ಯಾವುದು? Counsel for the petitioner submits that criminal petition number is connected with the present petition. Same is ordered to be, the office is directed to list both these cases together. And counsel for the petitioner undertakes to address his arguments on merits on the next date of hearing without fail, instead of arguing on IA 1 of 2023. And the HCGP has no objection if the learned counsel for the petitioner addresses his arguments on merits. Submission of the learned counsel for the petitioner is placed on record. List finally as a last chance. Interim order will be posted. Finally posted. Interim order will be extended subject to the condition. And no further adjournment will be given. Yes, next.
Serial number 15, K. Raghavendra.
But no further adjournment will be given. Counsel for the petitioner undertakes to address his arguments on merits on the next date of hearing. It is noticed that the petitioner is enjoying the benefit of interim order. And first again, petition is of the year 2022 and the petitioner is enjoying the benefit of the interim order. Learned HCGP filed IA 1 of 2023 seeking vacating of the interim order. Since learned counsel for the petitioner undertakes to address his arguments on merits, post matter of admission along with IA 1 of 2020. ಅದು IAR ಹಾಕಿದ್ದು ಆಯ್ತು ಫಸ್ಟಿಗೆ ಹಾಕಿ ಅದು ಮೊದಲೇ ಹಾಕ್ಬಿಟ್ಟಿದಾರಲ್ಲ.
Serial number 16.
But no further extension. Yes. ಕೊಡ್ತಾರ ಆಮೇಲೆ ಡೇಟ್ ತಗೊಳ್ಳಿ ಬಂದು ಆಯ್ತು 30 ಕೊಡಲ್ಲ ಬೇರೆ ದಿನ ಕೊಡ್ತೀನಿ. ನೆಕ್ಸ್ಟ್.
Serial number 16, Kulkarni Abdul Rashid Sikandar Saab, Rishikesh Gautam.
Yes. He is the petitioner.
He's the petitioner, it is number 3.
Accused number 3. In all, how many accused?
In the complaint, only one name is given and others. Accused number 3 is mentioned as sub-registered.
And also bank manager,
No, in the FIR, how many accused are there?
three members, my lord. 3 accused.
ಮತ್ತೆ? A1 is?
A1 is the Nagaraj.
ಏನವರು?
ICICI Bank agent on loan.
Who is A2?
A2 is the Manjunath of ICICI Bank.
He is also bank loan.
Bank official.
Yes, ma'am.
And the accused number 3?
Also sub-registered.
The present petition.
Investigation was not undertaken.
No.
No investigation.
No. The allegation in the complaint is that the complainant wanted to purchase the property. This is owned by 2%. He entered into the agreement of sale with those 2%.
Yes.
He approached accused number 1 Nagaraj, claiming to be the agent of the ICICI Bank on loan. And he required to provide all the documents. He was in contact with them. But they informed that loan is not sanctioned. Then he approached another person. Then he came to know that already loan was sanctioned. Then he opened the document and found that somebody impersonated purchased the property, taking loan from the ICICI Bank and mortgaged that property to the bank.
Allegations are very serious in nature.
Against the other people. And sub-registered. Allegation against me is not in the entire complaint.
Was it not your duty to identify the person who is executing the document? Sir, identification of the executant itself is in dispute now. No, you are supposed to identify the person. You cannot register the document said to have been executed by somebody else. When there is impersonation, sub-registrar is liable. He should insist for ID proof. He has to identify the person. Here the allegation is impersonation. How can you say that I am not responsible? Verify ಏನಿಲ್ಲ judgment ಕೊಡಿ ಏನಿದೆ ನೋಡಿ. Yes, ಎಲ್ಲಿದೆ relevant.
Following the aforesaid judgments, the court is sent to the court in the case of Sri Devraj P. in this case of so and others has had that. The learned counsel for the petition by Dr. Gupta would point out that the petition is no longer present data. Since the circulars could be an impediment to register documents, then the petition was to be non-registered. The housing crashed by vigilance of this court every petition for so and corrected cases stated following the vigilance decision not for the transfer either 1995. And yet another decision in 3 months after this
Is it a case of impersonation?
Impersonation case is also relevant. What is pointed out? I'll read one more paragraph. Where it was that when a document is presented for registration, fulfilling all the requirements, The permit has no option but to register the document unless the document is not in conformity with the provisions of the Indian Registration Act.
Registration, it is okay, sir, but what about identification of the person? He need not have to identify.
I will be entitled. If I am not satisfied, I will start delivering the candidate.
Date ಕೊಡೋದಿಲ್ಲ, date ಕೊಡೋದಿಲ್ಲ. I am very certain.
The relevant rules and registration was entrusted to the duty of registering documents according to the provisions of the Act, and he was not authorized to go into the genuineness or otherwise of the document presented.
Genuineness otherwise of the documents. He is not concerned about that. But he has to identify the person who is presenting the document for registration. For impersonation, he is responsible. Otherwise, it is the negligence. Check agide, sir, that is a settled position, I am saying you. Otherwise, it will be very dangerous position. What you now propose, it is a very dangerous proposition. Pass over. Pass over. ಏನಿಲ್ಲ ಸರ್ ಅದರಲ್ಲಿ ಏನಿಲ್ಲ. You are withdrawing. Counsel for the petitioner after addressing the argument for some time seeks permission to withdraw the petition. Permission is placed on record. Petition dismissed as withdrawn. IA 1 of 2024. In view of disposal of a criminal petition, IA 1 of 2024 also stands disposed of. Yes. ಅದೆಲ್ಲ settled position ಇದೆ.
Serial number 17, Victor Manoharan, Srinivas here.
Early hearing that, huh? Not yet admitted. I will dispose of your application. You filed IA 1 of 2024.
Government has.
State filed IA 1 of 2023. Victor Manoharan filed IA 1 of 2024. Seeking early hearing. I'll dispose of. Counsel for the petitioner filed IA 1 of 2024. Seeking early hearing. The matter is not yet admitted. Moreover, the petition is already listed. Hence, IA 1 of 2024 is disposed of. Next, petition is of the year 2022. Learned SCGP filed IA 1 of 2023, seeking vacating of the interim order of stay granted in favor of the petitioner. Learned counsel for the petitioner undertakes to address his arguments on merits and IA 1 of 2023. Yes, on merits. Yes.
One petition.
Who is the petitioner?
I believe
They are accused number 1 and 2.
Okay.
Petition is of the year 2022. Now you cannot seek the copy. Petitioners are accused number 1 and 2. What are the offense alleged? Yes. No investigation was undertaken in this.
No, my.
No, they are the public servants. Then
Simple is there.
yes. Yes. Type ಮಾಡಿಸಿ ಕೊಟ್ಟ
Type. ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ಬೇಗ ಸಿರಿವಂತರಾಗಬಹುದು ಎಂದು ಪ್ರಚಾರ ಮಾಡುತ್ತಿದ್ದು ದಿನಾಂಕ 25/8/2022 ಬೆಳಗ್ಗೆ 8 ಗಂಟೆಯ ಸಮಯದಲ್ಲಿ ನಾನು ನಮ್ಮ ಮನೆ ಬಳಿ ಇರುವ ಸದರಿ ತುಳಸಿದಾಸ್ ಯೇಸುದಾಸ್ ಮತ್ತು ದೇವಿ ಮತ್ತು ಮೇರಿ ಅವರು ನಮ್ಮ ಮನೆಯ ಬಳಿ ಬಂದು ನನಗೆ ನೀನು ಗಾರೆ ಕೆಲಸ ಮಾಡಿಕೊಂಡು ಹಿಂದೂ ಧರ್ಮದಲ್ಲಿ ಇದ್ದು ಏನು ಮಾಡುತ್ತಿದ್ದೀಯಾ, ನೀನು ಮತ್ತು ನಿಮ್ಮ ಮನೆಯವರು ಕ್ರೈಸ್ತವ ಧರ್ಮಕ್ಕೆ ಮತಾಂತರ ಆಗಿ ನಿಮಗೆ ಹೆಚ್ಚಿನ ಹಣ ಮತ್ತು ಆಸ್ತಿಯನ್ನು ಕೊಡಿಸುತ್ತೇನೆ ಎಂದು ಒತ್ತಾಯ ಮಾಡಿ ಹೇಳಿದರು. ಹಾಗೂ ನಾನು ಇಲ್ಲ, ಹಿಂದೂ ಧರ್ಮವನ್ನು ಬಿಟ್ಟು ಬರೋದಿಲ್ಲ ಎಂದು ಬೋಳಿ ಮಕ್ಕಳ ಸೋ ನೀವು ಉದ್ಧಾರ ಆಗೋದಿಲ್ಲ, ನೀವು ಮತಾಂತರ ಆಗದೆ ಈ ಊರಿನಲ್ಲಿ ಹೇಗೆ ಬದುಕುತ್ತಾರೆ ನಾವು ನೋಡುತ್ತೇವೆ ಎಂದು ಪ್ರಾಣ ಬೆದರಿಕೆ ಹಾಕಿ ಹೋದರು. ಈ ದಿನ ನಮ್ಮ ಗ್ರಾಮದ ಸುರೇಶ್ರವರು ಬೆಳಗ್ಗೆ ನಮ್ಮ ಮನೆ ಬಳಿಗೆ ಬಂದಾಗ ನಾನು ಸುರೇಶ್ರವರಿಗೆ ದಿನಾಂಕ 25/8/22 ತುಳಸಿ ನಾಯ್ಕ ಯೇಸುದಾಸರು ಮತ್ತು ಅವರ ಹೆಂಡತಿ ಬಂದು ಮತಾಂತರಕ್ಕೆ ಒತ್ತಾಯ ಮಾಡಿದ ವಿಚಾರವನ್ನು ನಾನು ಹೇಳಿದಾಗ ಸದರಿ ಸುರೇಶ್ರವರು ಸಹ ನನಗೆ ದಿನಾಂಕ 22/8/22 ಮನೆ ಬಳಿ ಇರುವಾಗ ತುಳಸಿ ನಾಯ್ಕ ಯೇಸುದಾಸ್ ಮತ್ತೆ ದೇವಿ ಮೇರಿ ಅವರು ಕ್ರೈಸ್ತ ಧರ್ಮಕ್ಕೆ ಮತಾಂತರವಾಗುವಂತೆ ಹಾಗೂ ಮತಾಂತರವಾದರೆ ಕ್ರೈಸ್ತ ಧರ್ಮದಿಂದ ಹೆಚ್ಚಿನ ಹಣ ಮತ್ತು ಆಸ್ತಿಯನ್ನು ಕೊಡಿಸುತ್ತೇನೆ ಎಂದು ಹೇಳಿದ್ದು. ಅದಕ್ಕೆ ನಾನು ಒಪ್ಪದಿದ್ದಾಗ ನನಗೂ ಸಹ ಸೋ ಒಂದು ಅವಾಚ್ಯವಾಗಿ ಬೈದು ನೀನು ಊರಲ್ಲಿ ಹೇಗೆ ಇದ್ದು ಬದುಕುತ್ತೀಯಾ ಅಂತ ಜೀವ ಬೆದರಿಕೆ ಹಾಕುತ್ತಾರೆ ಅಂತ ತಿಳಿಸಿದನು. ನಂತರ ಈ ಊರನ್ನು ಬಿಟ್ಟರೆ ಈ ಊರಿನಲ್ಲಿ ಸುಮ್ಮನೆ ಧರ್ಮಗಳ ವಿಚಾರದಲ್ಲಿ ಶಾಂತ ಕಡದಾಡುತ್ತಾರೆಂದು ನಮ್ಮ ಊರಿನ ಮುಖಂಡರಾದ ಗುರುರಾಜ್ ಮತ್ತು ಇತರ ಮುಖಂಡರಿಗೆ ಚರ್ಚಿಸಿ ಠಾಣೆಗೆ ದೂರು ನೀಡಲು ತೀರ್ಮಾನಿಸಿ ಈ ದಿನ ಬಂದು ದೂರು ನೀಡುತ್ತಿದ್ದೆ. ಲಂಬಾಣ ತಾಂಡದಲ್ಲಿ ಜನರಿಗೆ ಮತ್ತು ನನಗೆ ಸುರೇಶ್ರವರಿಗೆ ಒತ್ತಾಯದಿಂದ ಕ್ರೈಸ್ತವ ಧರ್ಮಕ್ಕೆ ಮತಾಂತರ ಮಾಡಲು ಪ್ರಯತ್ನಿಸಿದ್ದು ನಾನು ಒಪ್ಪದಿದ್ದಾಗ ನಮ್ಮನ್ನು ಅವಾಂಛ್ಯ ಶಬ್ದಗಳಿಂದ ಬೈದು ಪ್ರಾಣ ಬೆದರಿಕೆ ಹಾಕಿರುವ ಮೇಲ್ಕೊಂಡ ತುಳಸಿದಾಸ್ ಸೋನ್ಸರ್ ಮೇಲೆ ಕಾನೂನು ನೃತ್ಯ ಜರುಗಿಸಿ ಆನ್ ಬೇಸ್ಡ್ ಆನ್ ದ ಕಂಪ್ಲೇಂಟ್ FIR ಫೈಲ್ಡ್ ಮೇಲೆ.
Yes. $190. No, against the state. Against the state. Here it is not against the state. Against the private persons. Now 196 is very clear. Maybe, sir, 196 is very clear. Prosecution for offense against the state. First condition is it must be against the state. Here it is not against the state. No, first satisfy me about the wordings in the provision, sir. It is against the state. It is very clear. If something is alleged against the state, this provision comes into operation.
But similar circumstances, Miller, is sort of same. They then
No, no,
was
no.
trying to convert Miller.
No,
They
sir,
kindly
sorry.
received Miller.
Sorry, please convince me this.
So this also under section 16961 Millers. This was quashed Millers.
No,
because
sir,
of the
sorry.
Same circumstance.
Justify this.
May I read Millers this.
That is not, I am not bound by that, sir. I am not bound by that. Please convince me about this specific wordings against the state.
Against the
Is
state.
it the complaint against the state? Is there any allegation against the state? Then how you can refer to 196? I can understand if the accused is the state as the functionaries of the state. The section is very, very clear.
Prosecution for offense against the state and for criminal conspiracy to commit such offense. No court shall take cognizance of any offense punishable under section chapter or under section 153A. 153A, section 295A.
Yes, yes.
Because
Okay, na?
this is confirmed by the Supreme Court also.
Yes. Where is the Supreme Court judgment?
I'm passing on both the
When any detailed order by the apex court?
police fellows.
For the apex court.
They melons, it was under 153 melons. Here, it is 295 melons. Para number 4, the learned counsel to the petitioner submits the initiation of criminal proceedings under section 1.
Yaudu, what is that you are reading, sir?
Melons of the High Court judgment.
No, what is that you are reading?
Melons, this section, no, facts also is similar melons and this also melons, 191, 190. 195 melons, 196 melons.
Sir, I am asking you, you refer to AAR 2006 Supreme Court 2825, right?
Yes.
Which is the relevant paragraph.
11 parameters. Without melons.
Head note note citation model, sir.
This,
These are the basic things. And even this head note says, this is sanction is necessary only for taking cognizance. That stage has not yet arrived. We are still at the stage of registration of the FIR. There is no bar.
he was arrested, he was.
Maybe, maybe
After bail melons.
bar of sanction will not apply against registration of the criminal case, investigation by the police agency. Police arrested the accused, produced him before magistrate, magistrate remanded.
Here also,
Huh.
he was arrested and he was.
The bar is only for taking cognizance. The court has made it very clear. Order of remand will not amount to taking cognizance. It is against you. Take the head note. Just now you refer to. How it will apply to you? It is against you.
No, this.
Read the head note.
Did not melons, instigating Hindu to convert into Christianity.
What is the head note, sir? The proposition of law laid down.
No, I'm reading the entire.
Yeah, okay. Head note is against you.
This sanction of central government is necessary only for taking cognizance.
Yes. That is the settled position. I'll proceed with that. So good.
Venkat.
Give us the.
Petitioners being accused number 1 and 2 in crime number 241 of 2022 of Chennapatna Rural Police Station,
ಬೇಕಾದ್ರೂ ಕೊಡಿ ಸರ್ ನಿಮ್ಮ ಹೆಸರು ಯಾವ್ದು?
registered for the offense punishable under section 295A, 298, 504, 506, 511, read with section 34 of IPC, are seeking to quash the criminal proceedings initiated against them in the interest of justice, heard so and so. ಅದಕ್ಕಿಂತ ಮೊದಲು brief facts of the case are that respondent number 2 as informant filed the first information against accused number 1 and 2 stating that they being the followers of Christianity set up a church in Lambani Tanda and they try to forcibly convert the innocent Lamani innocent persons belonging to Lamani who are observing Hindu culture. The accused were offering money and valuables for converting the persons. The accused have also criminally intimidated the informant and other members of the community, deliberately insulted the religious feeling, etc., and therefore requested the police to register the case and to initiate legal action. Accordingly, the police have registered the case and took up an investigation. In the meantime, petitioners approached this court and got the interim order of stay, and therefore no investigation was undertaken. Third, so and so. Peruse the materials, point for consideration. My answer to the above point in the negative for the following reasons. It is the contention of the learned counsel for the petitioner that the petitioners belongs to Christian community and they have set up a church and proposing their religion. However, false allegations are made against them. It is the contention of the learned counsel for the petitioner that unless no, it is the contention of the learned counsel for the petitioner that there is a bar for proceeding with the registration of the criminal case in view of section 196 of CRPC. Since it is a complaint under section 295A of IPC. In that regard, he has placed reliance on the decision of the Apex Court in AAR 2006 Supreme Court 2825. The proposition of law highlighted by the Honorable Apex Court is that the previous sanction of the central government is necessary under section 196 of CRPC. Under section beta, previous sanction is necessary, central government beta. Previous sanction is necessary only for taking cognizance by the court and made it clear that the bar of sanction will not apply against registration of a criminal case or investigation by the police. It is also made clear that apprehending the accused by the investigating officer and the learned magistrate remanding the accused to custody would not amount to taking cognizance. Even though this decision is relied on by the learned counsel for the petitioner, the same is not helpful to him in any manner. Admittedly, no investigation was undertaken except registration of the FIR. Taking cognizance by the learned magistrate will be only after filing the final report by the investigating officer. That stage has not yet reached. Moreover, section 196 of CRPC refers to a prosecution for offences under such circumstances, I do not find any merit in the contention taken by the petitioner. He is not entitled for any, they are not entitled for any relief. Accordingly, I answered the above point in the negative and petition dismissed.
For further hearing, serial number 18, in Sriram Reddy, Vaijayanti Mala.
Well put. Awaiting this report. Yes, ಏನಾಗಿದೆ XCGP? NBW was issued against the respondent. What happened to that?
I have to verify your lordship.
Await ಅಂತ ಎಷ್ಟು ಸಲ ಹೋಗ್ತಾ ಇದೆ ಮಾ?
File,
I'll pass over the matter. 2:30 you come back.
please.
pass over.
Serial number 19, Krishnamurthy KR, PH Virupakshaya.
ನೀವು ಇದು ಕಾಸ್ ಲಿಸ್ಟ್ ನೋಡಲ್ವಾ? HCGP ನಿಮ್ಮ ಇದ್ ಮಾಡಲು ಸ್ವಲ್ಪ ಗಮನ ಈ ಕಡೆ ಕೊಡಿ. ಕಾಸ್ ಲಿಸ್ಟ್ ನೋಡಲ್ವಾ?
ಅಲ್ಲ, ಕಾಸ್ ಲಿಸ್ಟ್ ಪಾರ್ಟೀಸ್ ಇಲ್ಲ ಅಂತ they have not sent the file, your lordship.
ಕಾಸ್ ಲಿಸ್ಟ್ ನೋಡಿರ್ತೀರಲ್ವಾ? ಅದನ್ನ ಕಾಲ್ ಮಾಡಿದಾಗ ಒಂದ್ ಸ್ವಲ್ಪ ಅಲರ್ಟ್ ಆಗಿರ್ಬೇಕಲ್ಲ. ಪ್ರತಿ ಸಲ HCGP ಬನ್ನಿ ಬನ್ನಿ ಅಂತ ಕರೆದು.
I apologize, sorry, your lordship.
Every time this happens. ನಿಮ್ಮ ಓನ್ ಡಿಸ್ಕಷನ್ ಅಲ್ಲೇ ಇರ್ತೀರಿ.
I'll verify, your lordship. Ascertain and submit.
If this trend continues, ನಾನು ನಿಮ್ಮ ಪ್ರೆಸೆನ್ಸ್ ಅನ್ನ ನಾನು ನೋಟ್ ಮಾಡಲ್ಲ. I will note it as absent.
Please, your lordship.
Mere physical presence is not sufficient. Yes, 19. ಏನಾಯ್ತು? On merits?
Because I cannot ask one more.
ಆಯ್ತು.
Serving the court. Only for the second petition, all other facts are same except the thing is, the medical board has had only against the first petition as well.
ಅದೇನೋ on merits ಅದು ಹೋಗಿ ನೀವು
2020.
ತಗೊಳ್ಳಿ.
So far as him is concerned, it has not passed me out.
Yes. ಇದರಲ್ಲಿ ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ 287 is by accused number 1.
Accused
The other one is by accused number 2.
Accused. Next accused number 2, there is no finding by the games. Only against accused number 1, there is.
Investigation is not taken.
Charge.
Charge sheet is filed. Yes, correct.
This is on the basis.
Yes. Petitioner in criminal petition number 2827 of 2018 being accused number 1, and the petitioner in criminal petition number 2826 of 2018 being accused number 2. In crime number 161 of 2011 of High Grounds Police Station. Now pending in CC number 19168 of 2013 on the file of the learned 8th additional CMM court, learned and the court Hakbedi, CMM Bengaluru is seeking to quash the criminal proceedings. Seeking to quash the criminal proceedings in FIR number so and so. For the offense under section 338 of IPC. Brief facts of the case are that respondent number 2, respondent the informant Shri Muniraju filed the first information. Against accused numbers 1 to 6 and others, alleging commission of the offence punishable under section 326 read with section 34 of IPC. It is alleged by the informant that his wife Shailaja, 36 years, was suffering from backache and she was admitted to Mallige Hospital for treatment. The accused being the doctors working in the Maligi hospital advised to conduct surgery. Accordingly, she was taken to, she undergone surgery on 30/11/2009. Due to the negligence on the part of the accused, she went into coma after undergoing surgery. He was taken to M.I. Ramaya Hospital without his permission. And the informant came to know that it is only due to the negligence of the accused. She suffered coma, and therefore he requested the police to register the case and to initiate legal action. Next part. The investigating officer, after registering crime number 161 of 2011 for the offence punishable under section 338 of IPC, completed the investigation and filed the charge sheet against case number 1 and 2 for the aforesaid offence. The petitioners are seeking to quash the criminal proceedings initiated against them. Third source, career the materials, point for consideration. My answer to the above point in the negative for the following reasons. The petitioner in so and so being accused number 1 and the petitioner in so and so being accused number 2 are seeking to quash the criminal proceedings initiated against them for the offence punishable under section 338 of IPC. It is the contention of the learned counsel for the petitioner that accused number 1 accused number 2 is the surgeon, Allah.
Is the surgeon.
Accused number 1 is the
Anesthesia.
anesthetist. And accused number 2 is the orthopedic surgeon. They conducted surgery on the fateful day, that is on 30th November 2009. However, post-surgery, some complications arose, as a result of which the patient went into coma. Subsequently, she died. A complaint was registered by the medical board, Karnataka Medical Board. And as per the report, there was no negligence on the part of accused number 2, the orthopedic surgeon. However, something is alleged against accused number 1. It is also the contention of the learned counsel for the petitioner that when the petitioners approached the Karnataka Medical Council, Karnataka Medical Council, the first report by Karnataka Medical Council,
Yes, ma'am.
council or board?
Council, medical council, which is
Karnataka
at
Medical Council.
page 57.
The same was challenged before IMA, na? Challenged before IMA.
Challenged before the
Challenged before IMA, where clean sheet is given to the petitioners. Under such circumstances, there are no reasons to continue the criminal proceedings. Hence, he prays for allowing the petition. Per contra, learned counsel for the respondent opposing the petition submitted that even the Karnataka Medical Council submitted the report, which clearly makes out that there was negligence on the part of the accused. Even though IMA has given a clean sheet to accused number 1 and 2, the same is challenged before this court by filing writ petition number 10277 of 2021, and the same is pending consideration before this court. as no notice was served on respondent number 2 by IMA before passing the order. Under such circumstances, the order of the IMA cannot be taken advantage by the petitioners. The council also submitted that specific allegations are made against both the petitioners, and the materials on record disclose gross negligence on their part during and after the surgery. Under such circumstances, the petitioners have to face the trial. On perusal of perused material, point for consideration, I answer. Remain heard on perspective. On perusal of the materials on record, the informant has made allegation that even though his wife was suffering from backache and admitted to the hospital at the advice of the petitioners to undergo surgery, immediately after surgery, she went into coma. She was shifted to MS Ramaya Hospital without information or permission from the informant. And negligence on the part of the petitioners is the cause for the medical condition of the wife of the petitioner, wife of respondent number 2. During investigation, it revealed that the patient died. During investigation, it is found even though the patient was administered with anesthesia, accused number 1, being the anesthetist, has not taken care post-surgery, and accused number 2 has also not taken care when the patient was changed position from prone position, that is from prone position to supine position, during which the endotracheal endotracheal tube slipped, or it was bitten by the patient, as a result of which oxygen was not supplied to the brain, as a result of which she suffered cerebral cerebral death of the brain and went into permanent coma. Therefore, the investigating officer filed the charge sheet alleging commission of the offence punishable under section 338 of the IPC, as it is the gross negligence on the part of accused number 1 and 2 which resulted in the medical condition of the patient. They stated that the patient has later died. She died
She passed away, my lords, last year.
about a year back. Next part. The report of the Karnataka Medical Council is produced by the learned counsel for the petitioner. Where is that report? 56, sir.
57. The KMC order, my lord,
57.
57,
Yes.
and the conclusion at 64, my lord.
The Karnataka Medical Council, after analyzing the history of the patient and the treatment given to her in detail, arrived at the conclusion as under answer ಅಂತ ಮಾಡಿ page number 63 ನಲ್ಲಿದೆ ಪಿಂಕ್ 2 ಸ್ಲಿಪ್ ಹಾಕಿದ್ದೀನಿ. ಡ್ಯೂರಿಂಗ್ ದಿ ಶಿಫ್ಟಿಂಗ್ ಆಫ್ ದಿ ಪೇಷಂಟ್ ಅಂತ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ. This report by the Karnataka Medical Council was challenged before the IMA, Indian Medical Association. Tell the IMA report.
IMA is, I have filed on 16 February, I have filed. What's it? 16 February.
30th July 2020.
Please.
Yes. ಇಲ್ಲಿದೆ. Yes, I'm having IMA. ಏನು? Which has submitted. It has submitted its observations, which is as under. ಇಲ್ಲಿದೆ. Pink ಕೆಳಗಡೆ. After detailed deliberation, the ethics committee made the following observations. Full ಕೆಳಗಡೆಗೂ ಹಾಕಿ. It is stated that the said observation made by IMA was without serving the notice on respondent number 2, and therefore he has challenged it by filing writ petition number 10277 of 2021 before this court, and it is stated that the same is pending consideration. From the materials that are placed on record, including the sheet filed by the investigating officer, there are specific allegations made against both the petitioners, who admittedly conducted surgery on the wife of respondent number 2. Immediately thereafter, she suffered coma and died recently. The materials on record prima facie discloses that the petitioners being the medical officer, petitioner number 1 being the so-and-so, 2 being the so-and-so, were negligent in conducting the surgery. When there are prima facie materials to attract section 338 of IPC, I do not find any justification to quash the criminal proceedings initially. The petitioners are able to face the trial, taking necessary defense that is available for them. Next, ಅದಕ್ಕಿಂತ ಮೊದಲು ಈ ಕನ್ಕ್ಲೂಷನ್ ಗಿಂತ ಮೊದಲು learned counsel for the petitioner placed reliance on the decision of apex court in PB Desai versus State of Maharashtra and another to contend that it is only a rash and negligent act on the part of the accused will attract section 338, and such rash and negligent act should be deliberate, and no such ingredients are satisfied in the present case. The decision relied on by the learned counsel for the petitioner was rendered by the Honorable Apex Court when there was a challenge for conviction of the accused after a full-fledged trial. In the present case, only the final report is filed by the investigating officer, and no trial is undertaken. Even if the requirement of law to attract section 338 of IPC is to be accepted, admittedly there was grievous hurt to the person, as the wife of respondent number 2 slipped into deep coma immediately after surgery. Therefore, it was as a result of the act committed by the petitioners. And it is specifically alleged that there was a rash and specifically alleged that it was due to rash and negligent act on the part of the petitioners. Under such circumstances, prima facie, the requirement of section 338 of IPC are satisfied. And under such circumstances, the petitioners are not entitled for any relief. Accordingly, I answer the other point in the negative and proceed to first of all, dismissed. Yes.
Great.
Serial number 20. Prithvi Kiran Shetty, Harish Ganapati. Appearing for the petitioner in this matter, Your Worship. Offences are 499 and 500 of IPC. They have sought the quashing of the proceedings against the petitioner. On the previous date, I had addressed the arguments. I would like to submit some citations in.
Yes.
Lordship, this is a case regarding an allegation of defamation has been made against the petitioner herein for the statements that he made in the course of judicial proceedings. To briefly mention the facts, the respondent had, who was a witness in the case against the petitioner, had given a statement saying that the petitioner had threatened him and warned him not to give evidence.
Say first decision, it is after full-fledged trial.
No, Your Lordship.
After full-fledged trial.
Your Lordship, it is, there was no full-fledged trial in the matter. The magistrate had passed an order of issuing summons. This was challenged before the sessions judge.
What is the position, the proposition of law laid down in this case?
It was mentioned, Your Lordship, I have mentioned this case, brought this case before the Honorable Court just to show that the, 1 minute, Your Lordship, just to show that the exception can be pleaded, the High Court and the Supreme Court can quash the proceedings of defamation even with prior to having a full-fledged trial if there is a abusive process.
Where it is held?
Your Lordship, I will. Page number, paragraph 7 of that petition, paragraph 7, which is at page number 5 and 6, Your Lordship. The next question arises for consideration is whether reading the complaint and the report of the Treasury Officer, which was obtained pursuant to the order of the magistrate under subsection 1 of section 201, it can be said that a prima facie case exists for trial, or exception 8 to section 499 clearly applies, and consequently in such a case calling upon the accused to face trial would be a travesty of justice. The gravamen of the allegations in the complaint petition is that the accused persons made a complaint to the Treasury Officer Amravati containing false imputations to the effect that the complainant had come to the office in a drunken state and abused the Treasury Officer, additional Treasury Officer and the collector and circulated in the office using filthy language. And such imputations had been made with the intention to cause damage to the reputation of the services of the complainant. In order to decide the correctness of this averment, the magistrate, instead of issuing process, had called upon the Treasury Officer to hold an inquiry and submit a report, and the said Treasury Officer did submit a report to the magistrate. The question for consideration is whether the allegations in the complaint read with the report of the magistrate make out the offense under section 500 or not.
Section 499 of the IPC defines the offense of defamation, and Section 500 provides the punishment for such offense. Exception 8 to Section 499 clearly states that it is not defamation to prefer in good faith an accusation against a person to any of those who have lawful authority over that person with regard to the subject matter of accusation. The report of the Treasury officer clearly indicates that pursuant to the report made by the accused persons against the complainant, a departmental inquiry had been initiated and complainant was found to be guilty. Under such circumstances, the fact that the accused persons had made the report to the superior officer of the complainant, alleging that he had abused the Treasury officer in a drunken state, which is the gravamen of the present complaint and nothing more, would be covered by Exception 8 to Section 499 of the IPC. By perusing the allegations made in the complaint petition, we are also satisfied that no case of defamation has been made out. In this view of the matter, requiring the accused persons to face trial or even to approach the magistrate afresh for reconsideration of the question of issuance of process would not be in the interest of justice. On the other hand, in our considered opinion, this is a fit case for quashing the order of issuance of process and the proceedings itself. We therefore set aside the impugned order of the High Court and confirm the order of the learned sessions judge and quash the criminal proceedings itself. This appeal is allowed.
Observation is that by perusing the allegations made in the complaint, we are satisfied that no case of defamation has been made out.
Yes, Your Lordship, in the context of that matter.
Yes.
Therefore, without having a trial, the apex court quashed this matter.
Yes.
Now, the second case, Your Lordship, that is Arun Puri versus State of NCLT. This is also Supreme Court matter, Your Lordship.
Yes.
On page 19 onwards, from paragraph 18, I may be permitted to read paragraphs 18, 19, 20, and 21. We now turn to the question whether the benefit of any of the exceptions to Section 499 of the IPC can be availed of, and on the strength of such exceptions, the proceedings can be quashed at the stage where an application moved under, Section 482 of the Code is considered. In Jawaharlal Darda and others versus Manohar Rao, Ganpat Rao, Kapsikar and another, the reporting made by a newspaper about the proceedings in the Legislative Assembly touching upon the issues of misappropriation of government funds made for certain projects was the subject matter of complaint alleging defamation. The decision shows that the article being accurate and true reporting of the proceedings of the House, which was reported in good faith with respect of conduct of public servants entrusted with public funds intended to be used for public good, the protection was extended and the power under Section 482 of the Code was utilized. Paragraph 5 of the decision is as hereunder. It is quite apparent that what the accused had published in its newspaper was an accurate and true report of the proceedings of the Assembly. Involvement of the respondent was disclosed by the preliminary inquiry made by the government. If the accused, bona fide believing the version of the minister to be true, published the report in good faith, it cannot be said that they intended to harm the reputation of the complainant. It was a report in respect of public conduct of public servants who were entrusted with public funds intended to be used for public good. Thus, the facts and circumstances of the case disclose that the news items were published for public good. All these aspects have been overlooked by the High Court. Similarly, in Rajendra Kumar Sitaram Pandey, this is the same judgment that we have I previously dealt with, Your Lordship, so I will proceed to the next paragraph. It is thus clear that in a given case, if the facts so justify, the benefit of an exception to Section 499 of the IPC has been extended, and it is not taken to be a rigid principle that the benefit of exception can only be afforded at the stage of trial.
Yes.
That is with respect to this case, Your Lordship. The next case at page 24 is a matter decided by this High Court, Your Lordship. Shri M. Nagesh versus Shri Harish Chandra K.
Is again on the basis of the decisions of the apex court.
Yes, Your Lordship, but I would also like to mention a few parts of this. Page number 25, Your Lordship, paragraph number 8. The argument for the learned counsel of the petitioner is that the use of words builder mafia amounts to defamation within the meaning of Section 499 of IPC. Having gone through the entire complaint filed by the respondent before the Consumer Forum, I do not find that the alleged expression was used with an intention to tarnish the image of the petitioner or to bring disrepute to the petitioner. As rightly observed by the learned sessions judge, the said expression has to be understood in the context in which it was made and has to be read as a whole and not in isolation. This is the point which I would like to bring to your the attention of this Honorable Court, Your Lordship.
Yes.
And paragraph number 10 as well. Secondly, there was no publication of alleged imputations. Undeniably, these statements were made in the complaint filed by the Consumer Forum with a view to take appropriate action and not to tarnish the image of the petitioner. Furthermore, Your Lordship, at page number 27, there is a case decided by the Honorable Madras High Court, Shivaji Rao Gaikwad versus S. Mukundchand Botra. At page number 30 and paragraph 5, this court has carefully considered the submissions made on either side. The settled position of law is that there is no legal bar in filing a private complaint against a person alleging that he has made certain imputations in the pleadings before a civil court, which are per se defamatory. It is not necessary to wait for the final outcome of the civil suit, and the criminal complaint can be parallelly laid, seeking for punishment of the accused persons for making the defamatory statements. However, it is important to carefully see whether the allegations made by the accused persons in the civil proceedings are relevant to the issues and are absolutely necessary to be pleaded in order to substantiate the case of the accused in the civil proceedings. Sometimes the character and conduct of the person may also become necessary and important to be pleaded to substantiate the case. Ultimately, what is required to be seen
Why
is
you are relying on this?
to show that the context in which, that the conduct of the, where the statements are made regarding the conduct of the respondent, it was necessary to be made in that circumstance, Your Lordship. And this is what has been said in this case. Ultimately, what is required to be seen is whether the allegation made is totally unconnected or unwarranted to decide the issues involved in the suit. Furthermore, at page number 33, in the paragraph 11, in the present case, the petitioner had made the above averment against the respondent since the petitioner wanted to project the previous conduct or character of the respondent, which he thought was essential and relevant for the purpose of deciding the petition for the rejection of plaint. A reading of the entire affidavit filed in appeal number 443 of 2015 would show that the petitioner wanted to establish the fact that the entire suit was intended to malign and defame the petitioner, who had no dealings whatsoever with the respondent at the time. Next page, Your Lordship, 34. At paragraph 13, the above findings makes it very clear that the averment made by the petitioner in the affidavit filed in support of the rejection of the plaint petition had a major bearing while deciding the petition. It is also clear that the averment was not unconnected or unwarranted for deciding the issue involved in the petition. This court has gone to the extent of finding that the entire suit was a speculative one. In view of the above, the court is of the considered view that the averment made in the affidavit by the petitioner is not per se defamatory, and the same was made as a necessary averment in order to project the conduct or character of the respondent. The same has been sanctified by the final orders passed by this court, which has been referred supra. Therefore, the continuation of the criminal complaint against the petitioner will amount to an abuse of the process of the court, and the same requires the interference of this court under section 482 of the CRPC. Similarly, Your Honor, another case which...
That's similarly the bidding. Next.
Okay. The next ground, Your Lordship, is... sorry. So, next case is...
Now, what is the exception you are...
exceptions are exception number 8 and 8th exception and 9th exception, Your Lordship. May I be permitted to read them, Lordship? The 8th exception says, accusation preferred in good faith to authorized person. It is not defamation to prefer in good faith an accusation against any person to any of those who have lawful authority over that person with respect to the subject matter of accusation. In the context of this matter, Your Lordship, this accusation was made to the judge in terms of whatever the to mention that the respondent is not a credible witness, and therefore his statement saying that the petitioner has threatened him should not be relied upon. This was not made in the public, and in fact it was...
What good faith you are seeing in that, making all such allegations? What good faith?
Your Lordship, the petitioners had to show he had a right to protect himself.
Yes.
There was a threat that his bail would get cancelled.
Yes.
And he also knew the circumstances in which such allegations were made against him, because the respondent is a relative, is a brother-in-law of the petitioner, and he has made similar allegations. I'm sorry, not similar allegations. He has gone after other family members. So to highlight these circumstances, that is just as under section 155 of the Indian Evidence Act, Your Lordship, it talks about impeaching credit of witnesses. The credit of a witness may be impeached in the following ways: by the adverse party, or with the consent of the court by the party who calls him. Clause 1 says, by the evidence of persons who testify that they, from their knowledge of the witness, believe him to be unworthy of credit. Therefore, the petitioner made these statements, and in fact, he brought the respondent's own brothers, 2 brothers, who are not accused in this case, but who voluntarily came before the court
That
to
is
make
the
such
only
statements.
eighth exception, only eighth exception.
No,
of
that is the
Telecast.
8th exception, Your Lordship. Apart from that, there is a 9th exception as well. Imputation made in good faith by person for protection of his or others' interests. It is not defamation to make an imputation on the character of another, provided that the imputation be made in good faith for the protection of interests of the person making it, or for any.
So eighth and ninth,
Yes, Your Lordship.
yes, what is,
My lords, now all the judgments produced relied upon my
which is the portion, what is the defamation made? What is the
This-
defamatory statement made?
my lords, page number. The objections filed by the petitioner before the trial court, my lords.
Tell me the page number out.
Page number 46.
What is the defamatory statement made?
There are many defamatory statements, my lords, not.
Huh? Which paragraph?
Page number 47, my lords.
Yes.
Para number 4. The above case by complaint Lokayukta is at the behest of Dr. K. Mohan, who is entirely a dishonest, venomous, vicious person. Para number 4. And is known for wrong reasons in the 4, my lords.
Complaint is filed by PC number? By you, is it?
No, my lords. The facts of the case is, my lords, the petition.
No, you filed the private complaint.
Yes, Your
I
Lordship.
filed the private complaint, my lords. This is prevention of under PC Act, my lords.
No.
This
Yes.
special CC.
Huh.
The facts is this, my lords. He had been.
ಆಯ್ತು ಅದೆಲ್ಲ ಗೊತ್ತಿದೆ. What is the defamatory statement made by the petitioner?
Please. Page number 47, para number 4, my lords.
Hmm.
The above case by the complaint Lokayata is at behest of Dr. K. Mohan, who is entirely a dishonest, venomous, vicious person and is known for wrong reasons in the family. Dr. K. Mohan has committed serious omissions and commissions. Besides, he has no qualms for truth and values. To say the least, his own mother had filed an application for maintenance against him, and only after the order of the court he started paying. He was instrumental in causing Lokayukta prosecution against his elder brother Sri K. Uttappa, which is still pending in special CC number 160 of 2005. He had written numerous letters to the Forest Department and government against his second brother K. Prabhakar. Unable to bear the harassment, he took voluntary retirement. He targeted not only his brother but also his sisters and their husbands. The said K. Mohan was instrumental in fastening the above case against the accused. It is clear from the complaint given by the said Dr. K. Mohan Appaji dated 6/2017, he had earlier given a complaint dated 12/4/2004 against the accused.
All these are facts of the case. All are facts of this case.
No, my lords. The statement is entirely a dishonest, venomous, and vicious person. Is damaging my image. I am a district surgeon, my lords.
Maybe, sir. But in the special case, you are also one of the witness.
Yes, my lords.
What is the stage now? Special CC 61
Evidence is going on, Your Lordship.
still pending.
Yes, Your Lordship.
You are CW,
I'm CW.
that case? You are the complainant?
No, my lords, I'm not the complainant.
Then why you are cited as witness?
My lords, I am cited, for the Mahazar, I have cited as a witness. my lords.
Only Mahazar witness?
Yes, my lord.
Then this objection is filed to the memo dated 7/4/2017. What is that memo?
Your Lordship, the respondent had filed a complaint in the context of that case. He had filed a complaint to written a letter to the SP Lokayukta saying that the petitioner was threatening him and warning him not to give, threatening his life and warning him not to give evidence. Now, the SP Lokayukta issued an endorsement to that effect and gave this to the public prosecutor, who produced this endorsement with the memo. In this context, the petitioner came before the court and made produced this affidavit, Your Lordship.
And also in paragraph number 7, my lords.
Really, whether that letter is available?
No, Your Lordship.
Only the memo has been produced there, my lord.
Memo, where is that memo?
Up at page number 43. Vishaya Karnataka Lokayukta Madikeri Masudi.
By the police.
Yes, my lords.
Prosecutor ಏನು memo ಹಾಕಿದ?
How the Swami? The public prosecutor had filed a memo stating.
Previous page, Your Lordship, 41.
Letter sent by Inspector of Police. Where is that letter?
The next page, Your Lordship, 43. That is what they are referring to.
Yes. This letter is addressed by the Inspector of Police.
Please, my lord.
Yes.
To
The public prosecutor.
It is it is just an endorsement, Your Lordship, on the bottom left.
that is addressed to one Mohan Appaji.
Yes, that is the respondent, Your Lordship. It is basically an endorsement of what he has said. Of what the complaint or the letter the respondent had given.
So initially you made allegation against the petitioner
Please.
by writing a letter to the SP.
He had threatened me for my life, my lords.
Where is that letter?
My lords,
Apparently you must have made some allegations.
the complaint is not available with the court, my lords. The complaint which I had given is not available in the court records.
At least you should have that. See, this objection is filed in response to your allegations,
Please.
right? That
Yeah.
memo filed by the public prosecutor
Please, my lord.
is enclosed with the complaint made by you
Please.
to the Lokayukta police.
Yes.
And in response to that, this objection was filed.
Yes.
Now only memo is filed. Where is the letter by the?
It was not shown to us, Your Lordship. Only on the basis of this, my bail was
Where
threatened.
is that?
My lords, I will secure the letter, my lords. From the concerned police
When
authority.
you made certain allegations. The petitioner has filed a counter.
No, my lords, I had only, the thing is, unless we see the complaint given by me, we cannot decide that, my lords.
ಅದನ್ನೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಎಲ್ಲಿದೆ ಅಂತ.
I will produce, my lords. I will inquire in the, with the concerned police and I will produce before this.
ನೀವು ಏನೋ ಅಲಿಗೇಷನ್ ಮಾಡ್ತೀರಿ, ಅವರು ಅದನ್ನ ಡಿನೈ ಮಾಡ್ತಾರೆ, ಕೌಂಟರ್ ಅಲಿಗೇಷನ್ಸ್ ಮಾಡ್ತಾರೆ. Where is the question of defamation?
No, my lords, not only, yes, is totally assassinated my character, my lords.
ಎಲ್ಲಿದೆ ಸರ್ ಅಸಸಿನೇಷನ್ ಅಂದ್ರೆ ದೊಡ್ಡ ದೊಡ್ಡ
Dishonest, venomous. Which is, I am well-known personality in the Madikeri, my lords. The respondent is a well-known personality, my lords. He's a,
ವೆಲ್ ನೋನ್ ಸರ್.
No, my
ನಾವು
lords.
ಅನ್ಕೊಂತೀವಿ.
he's president of the Indian Medical Association of Madikeri district, my lords. And he's also a district surgeon.
First show me the letter. Let me see your language. What is your language?
Please, my lords,
ಆಮೇಲೆ ನೋಡ.
I will produce, my lords.
When will you produce tomorrow?
No, my lords, I need to inquire with the petitioner and
Sir, ಇವೆಲ್ಲ exercise ಮೊದಲೇ ಮಾಡ್ಬೇಕು.
please.
And that was the root cause. And both of you have not produced that.
Your Lordship, it is not within our knowledge. We only know of it through this memo and that endorsement.
ಆಯ್ತು ಅಷ್ಟೇ ಮೆಮೊ ಬಂದ್ರೆ why your objection runs into several pages?
Your Lordship, because of the fact that
ಎರಡು ಲೈನ್ ಹಾಕಿದ್ದಾರೆ. And
but-
according to you, you never seen that complaint.
no, Your Lordship, the main point here is that he has leveled a very serious allegation against
What
me.
is that?
That I'm threatening his life.
You have not seen the letter.
No, but the endorsement states that, Your Lordship.
What endorsement says?
May I, 1 minute, Your Lordship.
Page number 43.
ಪೇಜ್ ನಂಬರ್ 40. ಮೇಲಿನ ವಿಷಯ ಮತ್ತು ಉಲ್ಲೇಖಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ನೀವು ಮಾನ್ಯ ಪೊಲೀಸ್ ಅಧೀಕ್ಷಕರು ಕರ್ನಾಟಕ ಲೋಕಾಯುಕ್ತ ಮೈಸೂರು ಅವರಿಗೆ ಸಲ್ಲಿಸಿದ ದೂರು ಅರ್ಜಿಯನ್ನು ಮುಂದಿನ ಕ್ರಮದ ಬಗ್ಗೆ ಈ ಕಚೇರಿಗೆ ಕಳುಹಿಸಿದನ್ನು ದಿನಾಂಕ 22/3/2017 ರಂದು ಸ್ವೀಕರಿಸಿ ಪರಿಶೀಲಿಸಲಾಗಿದೆ. ನೀವು ದೂರಿನಲ್ಲಿ ನಮೂದಿಸಿರುವ ಅಪಾದನೆಗಳ ಬಗ್ಗೆ ಸಂಬಂಧಪಟ್ಟ ಸ್ಥಳೀಯ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ದೂರು ನೀಡಲು ಮತ್ತು ಪ್ರಕರಣದಲ್ಲಿ ಸಾಕ್ಷಿ ನುಡಿಯದಂತೆ ಬೆದರಿಕೆ ಹಾಕಿರುವ ಬಗ್ಗೆ ಮಾನ್ಯ ವಿಶೇಷ ಸರ್ಕಾರಿ ಅಭಿಯೋಜಕರ ಕರ್ನಾಟಕ ಲೋಕಾಯುಕ್ತ ಮಡಿಕೇರಿ ಅವರ ಮೂಲಕ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಮನವಿ ಸಲ್ಲಿಸಲು ಸೂಚಿಸಿ ನಿಮ್ಮ ದೂರು ಅರ್ಜಿಯನ್ನು ಮುಕ್ತಾಯಗೊಳಿಸಿದೆ ಎಂಬುದಾಗಿ ಈ ಮೂಲಕ ಮಾಹಿತಿ ನೀಡಲಾಗಿದೆ.
ಅದರಲ್ಲಿ ಏನಿದೆ ಸೀರಿಯಸ್ ಅಲಿಗೇಷನ್ಸ್?
ದಟ್ ಐ ಹ್ಯಾವ್ ಬೆದರಿಕೆ ಸಾಕ್ಷಿ ನುಡಿಯದಂತೆ ಬೆದರಿಕೆ ಹಾಕಿರುವ. Your Lordship, when
ಸೀರಿಯಸ್ ಆಯ್ತಾ?
Your Lordship, when
ಅದಕ್ಕೆ ನೀವು ಎಷ್ಟು ಪೇಜ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದಿರಿ? 1, 2, 3, 4 pages.
Your Lordship, when an
Making
accused
all sorts of allegations.
No, Your Lordship, may I make a submission? When an accused is given bail, one of the conditions is that he should not threaten a witness. The fact that the respondent is alleging that he has been threatened will result in the cancellation.
To deny that we have not threatened the witness.
Your Lordship,
What was the necessity for making all these allegations?
to show that there is a pattern in which the respondent
What
has
was the
gone.
basis? What was the basis? You don't know what is the allegation made by him, except saying that you are
It is an entirely false allegation, Your Lordship.
Dismiss the petition. No justification. You have not gone through the complaint filed by him.
Your Lordship,
And you filed 4 pages, 1, 2, 3, 4 pages of objections, making all sorts of allegations.
Your Lordship, these are matters of fact which have been and this
Face trial.
Your Lordship, as per the circumstances in which the allegations have been made have been brought to the
Circumstance ಅಷ್ಟೇ. PP on simple
Your
memo ಹಾಕಿದ್ದಾರೆ.
Your Lordship, the petitioner would have been remanded to custody again.
ಎಲ್ಲಿದೆ bail cancellation application ಎಲ್ಲಿದೆ?
Illa,
Where the
application is not there, Your Lordship.
Unless the application is filed, do you mean to say the bail can be cancelled?
No, Your Lordship,
Then
my apologies. That is not
There
what
must
I
be
meant.
some justification.
Yes,
PP has filed, learned PP has filed only simple memo,
yes, Your
bringing
Lordship.
it to the notice of the court.
Yes, Your Lordship.
No further action is taken.
Yes, Your Lordship.
Why you propose to file the objections?
Your,
That too 4 pages.
Your Lordship, that because false allegations were made against us, he was under an apprehension.
Allegation.
He is,
One line of allegation that he is giving threat to the witness.
yes, Your Lordship.
It is suffice on your part. I have not made any, I have never threatened the witness. That was sufficient.
Indeed, Your
Why
Lordship.
4 pages of allegation?
There was an apprehension. The petitioner was under serious apprehension.
There
that
must
his
be
bail-
some reason.
Yes, because the
Apprehension and
in
purpose.
terms of family, Your Lordship, kindly,
Petitioner being the accused number 1 is seeking to quash the criminal proceedings. Initiated against him. Petitioner being accused number 1 is to quash the order dated 27/9/2021. Passed in PC number 19 of 2018. On the file of the Honorable Learned Principal Civil Judge JMFC Madikeri. Taking cognizance for the offence punishable under section 499 and 500 of IPC.
Your Lordship, one submission.
And directing registration of the FIR. And also to quash the further proceedings in CC number 1323 of 2021. Pending before the trial court for the aforesaid offence. Brief facts of the case are that respondent has filed the private complaint in PC number 19 of 2018 before the trial court against accused number 1 to 3, alleging commission of offence punishable under section 499, read with section 500. It is alleged that the accused in the private complaint this accused number 1 is the only accused in special CC 61.
Yes, your lordship.
Accused number 1 is the accused, special CC number 61 of 2016. On the file of the learned principal, district and sessions judge Kodagu Madikeri. Initiated for the offense. What are the offense alleged?
In the instant matter, section 499 and 5.
Adalapa, special CC 61.
That is disproportionate assets matter, your lordship.
Alleging that the petitioner herein amassed wealth which is disproportionate to his known source of income.
And under section 13(1) clause C, my lords.
It is stated that the respondent herein is one of the witness in the said case. He alleged that the petitioner, accused number 1, is threatening him not to give evidence. Same was brought to the notice of the court by the learned prosecutor by filing the memo in a special CC 61 of 2016. The petitioner, accused number 1, filed the statement of objection to the memo dated 7/4/2017 filed by the special public prosecutor. Even though the memo contains only 2 sentences, the statement of objections runs into 4 pages. It is the next part. It is the contention of the respondent that the petitioner has made defamatory statement in the statement of objection filed in special CC 61 of 2016 and therefore filed the private complaint PC number 19 of 2018. The learned magistrate took cognizance of the offence and CC number 1323 of 2021 was came to be registered. Being aggrieved by the same, the petitioner is before this court. Heard so and so. Point for consideration, my answer to the point in the negative for the following reasons. The materials on record disclose that the petitioner is the accused in special CC 61 of 2016. It is alleged that he, being the public servant, amassed wealth disproportionate to his known source of income and committed the offence under section 13(1)(e), read with section 13(2) of PC Act. The respondent complainant is one of the witnesses in the said case. It is stated that respondent has complained to Lokaयुcta police that he is receiving threatening calls from the petitioner not to give evidence in a special CC 61 of 2016. This fact was informed to the learned prosecutor by the investigating officer, who in turn filed the memo dated 7/4/2017 before the special court, which reads as under. The prosecution memo on time. The prosecution begs to submit that the knowledge of this honorable court the prosecution begs to bring into the knowledge of this honorable court the letter sent by Inspector of Police, Karnataka Lokayukta, Kodagu District. Next, it is the specific contention of the learned counsel for the petitioner that the petitioner never came across the contents of the letter said to have been written by the respondent addressed to the Inspector of Police, Karnataka Lokayukta. The statement of objections filed by the petitioner is only in response referred to above. Even though the memo contains only one sentence, the statement of objections filed by the petitioner runs into 4 pages. The petitioner runs into 4 pages. Next. The respondent in the private complaint PC 19 of 2018 stated that he is a doctor by profession, having great respect and repute in the society. He is serving as the president of Indian Medical Association, Kodagu District, and also the president of Rotary Club Madikeri. He is also the president of Karnataka Kodagu Badminton Association and working as professor in KVG Medical College, Sulya. And also visiting doctor to VIVUS Hospital, Ashwini Hospital, and he is organizing free ENT camps since several years. He was born and brought up in Kodagu district. He is having family members and friends throughout the district of Kodagu, as well as in the state of Karnataka. ಇದನ್ನ ಕೆಳಗೆ ಹಾಕಿ ಈಗ ನಾನು ಹೇಳಿದ್ದಷ್ಟಲ್ಲ. Yes, ಅದಕ್ಕಿಂತ ಮೊದಲು ಇನ್ನೊಂದು. In the statement of objection filed by the petitioner, the petitioner has stated that the respondent is a dishonest, venomous, VENOMOUS, vicious, VICIOUS person, and is known for wrong reasons in the family. He is instrumental in causing Lokayukta prosecution against the eldest brother, Sri K. Uttappa. He is instrumental in fastening the case, special CC number so and so, against the accused. It is alleged that respondent is wreaking vengeance with the false accusations.
Let's even para number 7 also, let's yes. Alleged defamatory. Para number 7.
It is also alleged that respondent has harassed his own brothers sisters, and brother-in-laws extracted huge amount is alleged that even though respondent joined the services with Mrs. ESI Hospital, Bengaluru, during 1989, he took leave in the year 1996, went to Saudi Arabia, worked in government hospital for 2 years, 3 months without informing the government. A criminal case was registered against him in crime number 129 of 2004. Next paragraph. It is also alleged in the statement of objection that during 2013, the respondent gone astray, ASTRAY, he triggered Lokayukta. He filed the suit OS 129 of 2013 and also triggered Lokayukta to conduct a raid on the accused. He has written a letter to Additional Director General of Police, which resulted in suspension of the accused. Now the allegations are made by the respondent, only to see that the bail granted in favor of the accused is cancelled.
Your Lordship, the accused mentioned that the respondent was instigating other witnesses also against the petitioner in the same matter, Your Lordship. That's why it was necessary to bring the conduct of the witness or this respondent before the Honorable Court therein.
It is further alleged respondent, who is a witness in the criminal case, has instigated the investigating officer, fabricated the false records with malice and ulterior motive, pursuant to the dishonest designing to corruptly and falsely make out a case against the accused. It is suggested that the petitioner, being the accused in the said case, is having other documents that would expose the sinister motive of the respondent. On going through the statement of objections filed by the petitioner, it is clear that serious allegations are made against the petitioner, against the respondent, which are prima facie defamatory in nature. Even though the learned counsel for the petitioner has placed reliance, on the decision of the apex court in 1999 SCC 3134 in support of our contention that no prima facie case to constitute the offence under section 500 of IPC is made out, and under such circumstances, and further, the case in hand falls within the 8th and 9th exception to section 499 of IPC, and therefore the criminal proceedings is to be quashed. She also placed reliance on the decision of the apex court in Arun Pure versus State of NCT of Delhi and others. The report of report agida ನೋಡ್ಕೊಳ್ಳಿ. In support of a contention that if prima facie the allegations complained of falls within any of the exceptions under section 499, the same can be taken into consideration to quash the criminal proceedings under 482 of CRPC. Placing reliance on, she also contended that the benefit of such exceptions to section 499 could be extended to the accused, and by quashing the criminal proceedings under section 482 of CRPC. Next, learned counsel for the petitioner placed reliance on the decision of this court in M. Nagesh versus Sri Harishchandra K5. Criminal petition number 7405 of 2016, date of disposal of node action. In support of a contention that the expressions made in the allegations made in the statement of objection was without any intention to tarnish the image of the petitioner. And there was no publication of any of alleged imputation. And under such circumstances, no offense whatsoever is made. The proposition of the proposition of law laid down in those decisions are very well settled. The same are to be applied to the facts of the present case. It is the specific contention of the learned counsel for the petitioner that the petitioner was never communicated with the complaint given by the respondent to the Inspector of Police, Karnataka Lokai.
Your Lordship, the
Petitioner is not aware of any of the allegations
Your Lordship,
made
may I
by
make
the
a submission?
respondent. In the said, it is the specific
Your Lordship, the petition, yes, but the respondent himself and family.
statement of objection. It was definitely not for private circulation. Under such circumstances, there are prima facie materials to constitute